That's a win for us.
And then we educate youth through our Juvenile Justice Jeopardy game.
Where's the blue team?
We also work with law enforcement agencies to create developmentally appropriate, trauma-informed, equitable policies and practices. And finally, we conduct research on the structural factors that impede progress in police-youth interactions. What's extraordinary about our impacts is that officers are seeing that when you don't arrest a youth, you don't immediately endanger public safety. You often increase it. And that is the culture change that we're focused on.
All righty. So that was an introductory video by Strategies for Youth. And this is your game board. Can everyone see the game board? So I'm going to take roll call real quick. So if you could just chime in that you're here, present, and that you see everything. I'll start with Team Cohen.
We're here.
Excellent. Thank you.
Present.
Team Wilson.
Present.
Team The Replacements.
Here.
Team Lucero.
Here.
Team Zenoff.
We're here.
Team Nevada Help Desk. Uncle Gary, you there?
I'm here. I see everything.
Okay. And Team Village Foundation with Mr. Jones.
We're here. We see everything.
Excellent. 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 All righty. Let me just stretch the game out a little bit. Okay. So we're going to go ahead and get started. Let me explain the game board. Please bear with me for those who have already heard this. In front of you, you will see 5 different categories with $100 to $500 amounts. Behind those numbers will be questions and answers for your team leader to read and then discuss that among the team member that is going. Right now, Team Wilson, you are first up. The coin has already been flipped and the game has chosen you to go first. So Team Wilson, you will be first. I will ask, identify each team, ask you to identify a category and a dollar amount. We do like to go from 100 to 500, but if that's not how you choose to go, then we'll work with that as well. But I would prefer if we go 100 through 500 that way, because the questions really build on one another. You'll have an opportunity to discuss that question with your team and then ultimately come back to me with a final answer. I encourage the other 6 teams, while a team is up and is participating, that those team leaders on mute, obviously, discuss that question with your team and engage your team in that question and see if they come up with the same answer, the right answer. And that way, everyone continuously is participating in this game for all 25 questions. Any questions about that? Okay. It looks like, Dr. Malone, it looks like everyone is on mute, or are you controlling the mute button? I just want to make sure that everyone is on mute so we don't have any over talking and background noise.
They have control.
Okay, excellent. So right now, if there are no general questions, Team Wilson, you are up and you are free to choose a category and dollar amount.
Interacting with the police for 500.
Interacting with the police for 500. Hold on a second. There you go.
Can't see the picture.
How should you use your right to remain silent when in police custody? A, don't say a word to anyone. B, say I don't want to speak with you anymore. I want to remain silent. C, say I don't want to talk to you. I want my lawyer. Or D, wait for a parent and speak only when he tells you to. Give us a second, please.
Sure.
Team Wilson is going to select D, wait for a parent and speak only when he tells you to.
D, final answer.
Final answer.
That would be incorrect.
Does anyone else want to try and guess?
We can give it a go, the replacements.
Okay.
We choose C as our final answer.
That is correct. And this is what we talked about before. Because we're primarily dealing with juveniles in this particular game, in some instances, police officers will accept that they want to speak with a parent and will stop talking to or stop questioning that particular juvenile because parents are your legal representation as well. This is where we talk about the letter of the law and the spirit of the law. And I know we have police officers who are on with us today, and I certainly encourage them to speak up and talk about this a little bit more when it comes to Mirandizing police officers, or I'm sorry, when it comes to Mirandizing juveniles.
Just one thing all young people should know is that when you or anyone who's in custody says, I don't want to talk to you, I want a lawyer now, law enforcement has to stop asking you questions. So if you want to say that and wait to speak to your parent, that is a good thing to do too, because sometimes you may not agree with what your parent wants you to do. So when you say, I don't want to talk to you, I want a lawyer, all questioning by law enforcement has to stop. And then you are entitled to have a lawyer. And if you can't pay for one, one will be provided to you by your county.
Any other questions about this question? This is actually a really big question and really important when it comes to understanding your right to remain silent. In order for your right to remain silent to be in effect, you must be in custody, which means you are not free to leave, and they must be talking to you about the charge for which you were arrested. So if you're caught with a gun, they're questioning you about where you got the gun, who gave it to you, where'd you get the ammunition, all those sorts of things will pertain to that particular arrest, and they must Mirandize you at that point. Any questions? Okay, excellent. So unfortunately, because the replacements answered that question and they got the points, it's actually going to skip them now for their turn. And Team Lucero, you are up.
Lucero's going to go with offenses 500.
Offenses for 500.
Malik agrees to be a lookout while Anthony breaks into a house. Anthony takes a laptop and cash, all worth $3,000. They leave together. What could Malik be charged with? A, nothing, only Anthony committed a crime. B, Malik could get in legal trouble for acting as a lookout for Anthony. C, both Malik and Anthony could be charged with burglary and grand larceny. Hold one moment.
Yep.
Lucero's choosing C. Both Malik and Anthony could be charged with burglary and grand larceny.
C is correct. And I'm sorry, for Team Lucero, Officer Washington and Officer Mitchell, do you want to talk a little bit more about why Malik and Anthony could be charged under Nevada law?
We're having a discussion with our group right now.
Okay.
It'd be great to hear that discussion if we could. Well, for those who aren't able to hear the discussion going on, when you're a lookout and you're working with someone who's committing a crime, it's considered accomplice liability or joint venture. So whatever the main person in the crime is doing, since you're helping them, you'll be charged with doing it too. So that's why, even though you were only the lookout and Anthony was doing the one of breaking into the house, which is burglary, and taking a laptop and cash worth more than $3,000 or so, which is grand larceny, you're going to be charged with that too. Everybody understand? Does that make sense?
Yeah, something happened to the game. It's now out of, oh, bear with me one second, friends. I'm sorry. Bear with me one second. Okay, I think we're back. Can everyone see me and everyone hear this, see the screen?
Yes.
Okay,
Yes.
okay, thank you.
Yes.
Yes.
Okay, Team Xenoff, you're up.
Team Xenoff would like offenses part 2, today's daily double for 500.
Today's daily double. I like that.
All right, guys. You take your mom's car without permission and go for a ride with a friend. Mom calls the police. What could happen? A, once you tell the police you just borrowed the car, you'll be fine. B, the police may charge you with an unlawful taking of a vehicle. Or C, police may charge you with grand larceny of a motor vehicle.
Officer Rose, we'd love to hear the conversation you have with your group.
Team Xenoff chooses C. The police may charge you with grand larceny of a motor vehicle.
Okay, C, final answer.
So I just want to make it clear to everybody that even if your mom calls the police and then realizes it's you who took the car without permission, her own child, it's too late. The charge, the process has begun, and it may be the case that you cannot simply get it dismissed. So if you're going to take somebody's car, get permission and or leave a message, leave a note, because you don't want the police getting involved and getting a charge for doing this, because a grand larceny charge is a pretty serious charge. Any officer want to comment on this to clarify it?
Mr. Clark, is this answer correct?
I'm sorry?
Is the answer correct?
No, it was not correct. The correct answer is the police may charge you with unlawful taking of a vehicle. So the correct answer, I was going to give that Uncle Gary an opportunity to answer this question, because the way, unfortunately, technically, the way that the game is set up, if an answer is wrong, it rolls to the next team to answer the question. So when I click the right answer, it's actually going to give Uncle Gary's team the points. And that's a technical problem that we're having with the game, and I apologize for that tremendously.
Which is why
See
everybody's
what I mean? So
winners. That's why everybody's gonna be winners today.
yeah,
Right.
yeah, it's a technical problem. So now when I click it going forward, it's actually going to skip over Uncle Gary and gonna go to Team Village Foundation.
Dr. Malone, maybe you can help us fix that.
Sure, put in a work request.
Okay.
So Mr. Jones, Village Foundation, you're up, sir.
Okay. We're going to take juvenile justice overview for 500.
Okay.
Okay, question. What is disproportionate minority contact, DMZ? Is it A, a term used to describe facts that youth of color are stopped, arrested, incarcerated at a higher rate than whites? B, a term used to describe the fact that youth of color commit at a higher rate than white youth? C, Bizarro's latest song? Or D, a test given to youth to determine in the detention center? Okay, we're gonna mute and discuss. Okay, our group is going with A, a term used to describe youth of color are stopped, arrested, and incorporated at a higher rate than white youth. It's our final answer.
A, final answer. Correct.
Yes.
Team Cohen.
Yes. We got it.
All right, Team Cohan will go for juvenile records for 500.
Juvenile records for 500.
Which is true about your juvenile record? A, most juvenile records will be automatically sealed when you're 21, or B, most juvenile records are automatically sealed when you turn 18. Okay. So Team Cohan chooses A, most juvenile records will be automatically sealed when you're 21.
A, most juvenile records will be automatically sealed when you turn 21. Excellent. So this is
Yay.
important. I'm sorry.
I was just yelling yay.
Okay. So this is important to understand that some jurisdictions are different. So Nevada may be different than California, may be different than Kansas City. It may be different across different jurisdictions. So you have to make sure that you understand what your jurisdiction does. Where most of this goes wrong for our juveniles is that if they do not successfully complete probation, then the records will not be sealed. They will stay open. So if your probation was to go on 6 Saturdays to pick up trash on the side of the freeway or clean up playgrounds or whatever the case may be, and you don't show up for that, then your probation is never completed and your record will never be sealed. And some, you have to have an attorney actually petition the court for your records to be sealed. So this is not the same in every jurisdiction. Excellent. Team Wilson.
Juvenile records for 400.
Juvenile records for 400.
At the age of 14, you are adjudicated delinquent for robbery. A felony is your record public. Oh, I'm sorry. At the age 14, you are adjudicated delinquent for robbery. A felony is your record public. Team, what do you guys think? Team Wilson has decided B. Final answer.
B, final answer. Correct. Juvenile records are not public.
In Nevada, just
Yes, in Nevada.
please
We're planning on,
remember, yeah, there are some states where some charges would be. So remember, we're just talking about state law in Nevada.
team, the replacements.
All right, we're gonna go with offenses for 400.
Offenses for 400.
Your principal sees your TikTok saying you've got weed to sell. She asks you to open your backpack, where she finds 1 ounce of weed. What could happen? A, school suspension. B, charge of possession of marijuana. C, both A and B. Or D, nothing will happen. She has no right to look in your backpack. Give us 1 second.
Okay.
Sure.
All right, we're gonna go with C as our final answer.
C is the final answer. That is correct. So there will be administrative sanctions because it was at school, and there could be criminal penalties as well. Excellent answer.
We want everybody to know that a lot of principals are looking at what their students are saying online. So don't say it, don't bring it to school. Just be aware that what you may think is private is not. And every time you bring drugs to school, you're putting yourself at great risk of getting arrested and getting, as Robert said, a school sanction like suspension or sometimes expulsion.
Team Lucero.
Team Lucero will take interacting with police for 400, please.
Interacting with police for 400.
Perfect.
And police look at your Instagram, Twitter, Snapchat, Facebook, TikTok, and other social media posts. A, no, they have no legal right. B, yes, but only if you give them permission. C, yes, police can look at your public social media whenever they want. Team Lucero says C.
Good.
C. Excellent. This is actually a great question. This is important to understand. Police do not need your permission or a warrant to look at your social media. However, if they want to look at your laptop or your tablet or your cell phone, they would need a warrant to look at the things in your phone, including your email and pictures and text messages. But they do not need a warrant to go on public social media sites and look at what you're doing. And a lot of kids confuse the two. They do need probable cause, to believe that that device was involved in a crime. So if you lend your laptop to someone and they believe that that laptop was involved in a crime, they would need a search warrant based on probable cause to be able to look in your laptop for pictures, text messages, emails, websites that you have visited. They can look at all of that within that particular device. So it's important to understand the difference. Any questions about that? Okay, hearing none. Team Xenoff.
Listen up, guys. We'll take juvenile justice overview for 400, please.
Juvenile justice overview for did you say 400?
Yes. You are 14 years old, truant, meaning you don't go to school, run away from home, and are found with alcohol by the police. Have you committed an offense? A, yes, or B, our answer is A, yes.
Would you like to further comment on what crimes have been committed? Because there are actually several crimes that have been committed here.
Well, maybe I'll jump in for Team Xenoff here. Being a minor in possession is to be found with alcohol, right? And truancy and running away from home are called status offenses. And sometimes you can be brought into the probation world because of not going to school or running away from home or being found in possession with alcohol. But sometimes if you are brought into probation for a status offense and you don't follow the rules of probation, that status offense becomes a criminal delinquency charge. So if you do these things, you got to be careful. There can be big legal consequences.
Thank you, Lisa. Uncle Gary.
I'm here. Okay.
You are up, sir.
Okay, thank you. Juvenile justice overview for $100.
Juvenile justice overview for 100.
Okay, cool. At what age can you be charged with a crime in Nevada? 10, 12, or any age? So Mr. Rowe, I agree with you. Open discussion is probably a little bit more informative. My team is Amani, Miel, Stephanie, and Laura. So if y'all would unmute your mic so the team members can hear, or everybody can hear how we derive at our answer.
Great.
So we're gonna talk out here?
Yeah.
Okay, perfect. Well, I will go first. 10 seems a bit too low, but 12, it's right before 13. So I'll toss my hat in and say that I think it's 12.
Okay, Stephanie, Laura, Amani.
Yeah, I'm saying 12 too. I think 10's a little bit young.
Okay. Amani. Okay. Stephanie. Okay, well, everybody's not participating. How you doing, Miss Young? The doctor? Oh, she's not on. Okay. All right, so our group, our team said 12. We'll go with 12 years old.
Can you guys hear me now?
Oh, there you go. Okay. Good.
Oh, okay. So I had the wrong mic selected, sorry. But I was gonna say C, any age, because I know that, you can get charged as a minor for anything, or I think that's the way it works. I'm not too sure.
Okay, so Dr. Clark said if it's the majority would win. So we got 2 for 12 and 1 for any age. So we'll go with B, 12.
B12, final answer. So that answer is actually incorrect.
Okay.
And unfortunately, it's rolling to the next team. Mr. Jones, would you like to take a guess?
We're gonna say, okay, it would depend on the offense. For example, if you're talking about a violent felony, like murder or attempt murder, some degrees of property crime also. But we're gonna say A as the correct answer.
A.
Could I ask what was the reason behind that answer?
Sure. We understand that in Nevada, there are certain offenses that, regardless of what your age is, you can be prosecuted for it.
Right.
Now, simply because you're prosecuted doesn't necessarily mean that the adjudication process would result in jail time. Oftentimes, the juvenile adjudication process oftentimes involves counseling, depending on the home and circumstances such as education level and age of consent. So that's why we chose A as the correct answer.
Well, actually, Dr. Jones, you're right. 10 is the right answer, but it has nothing to do with the kind of offense you've committed. Any kid at the age of 10 committing any kind of crime, that can be trespass or shoplifting or murder, will be charged. If you're under 10 and you commit those offenses, you cannot be charged with a crime. So Nevada is a state with a lower age limit. There's some states that have none. So the day you're born, like in Florida, you could be charged with something, let's say disturbing the peace for crying, right? Other states like Massachusetts just changed its law. It went from 7 to 12. So you have to be 12 before you can be charged with a crime. Nevada is 10. So anybody out there who has a 10-year-old brother, sister, cousin, think about it. I don't think any of the officers on this call has probably arrested a 10-year-old, or I hope not, because we all realize they're kind of young and just need to be told what to do. But we want everybody to know that that is what the law says in the state of Nevada.
Excellent, excellent, excellent.
Thank you.
Okay, Team Cohen.
All right, Team Cohan will choose offenses part 2 for 400.
Offenses part 2 for 400.
You and Simeon plan to fight each other over Sean after school. When you start fighting, others watching join in. When the police come, it is out of control. What could happen to you? A, nothing. It's not your fault the fight got out of control. B, you could be charged with the fray for making an agreement to fight in public. Or C, you could be charged with disturbing the peace. Or D, B, and C. 1 second. Team Cohan would choose D, B, and C.
D, B, and C. Correct.
How could somebody know, officer, that you were planning, you had an agreement to make a fight? Where would they see evidence of that possibly?
Kids are saying the internet, social media, things like that.
So remember that other question we had before about can police look at the internet and the media and what you're saying publicly? Well, if you plan to fight someone and you put it out there on the social media outlets that you might use, that's how an assault and battery charge could ratchet up to an affray charge because you made an agreement. And those are two serious charges that you don't want to have.
Perfect, thank you.
Excellent. Team Wilson. Team Wilson, you still there?
Interacting with police for 300.
Interacting with police for 300. Excellent question.
Can a male police officer pat down a girl? A, always. B, never. Team Wilson will go 8, always.
Would you like to expound upon why it's always? Or why does your team think that it's always?
All right, so we are going off mute. We're gonna have a representative come up. You're gonna
Okay, excellent. Excellent.
Because a male officer can pat down a girl, but he cannot search her.
Can you tell me what's the difference between a pat down and a search?
A pat down is if he feels that he's in danger. A search is if he has to search her, like to read her Miranda rights.
Okay, well, a pat down usually uses the back of the hands to check for a weapon, right? And that's, so you're exactly right. An officer can always do that to make sure they're safe, right? And maybe the officers who are game leaders can even demonstrate what a pat down looks like. Can a girl ever kick or punch an officer who's doing a pat down on her? What do you guys think?
That's like a really, like, one thing I really enjoy about this activity as a whole is just how much it's making us think. I feel like a lot of these situations are so subjective. I don't know if like personal preference or emotion is like is held into account, but like if a girl feels that she's being violated, you know, let's say by a male police officer, I mean, like, what is she technically allowed to do within her rights, you know, as a woman?
Yay.
So I don't know.
Perfect question.
Right.
That's what I was hoping you'd ask. So to all the girls out there and to the young men who have sisters and cousins and friends who are girls, let's think about this. As a girl, you may ask the male police officer for a female officer to conduct the pat down and even a more in-depth search, which would mean having your pockets pulled out, looking into your bag and so forth. But you are not legally entitled to have a female officer. And I'm guessing that Nevada's, Las Vegas's police department is not unlike other police departments in that there are only about 15% women on most police department staff, so in their roles. So you may not even be able to find a woman patrol officer necessarily who can come conduct the pat down. So part of the point of this, and I'm so glad there's so many officers playing the game here, is for you to see what a pat down would look like if someone was conducting on you, where they're going to touch you and what you should do. So if you're a girl, let's rehearse this. You want to say, may I have a female officer conduct the pat down? And if the officer says no, maybe the officers in the room can showcase what a pat down would look like. And if any of you are thinking about what you want to do with your futures, we hope you will think about being a police officer who's a woman. We need a lot more women in the field to make it 50-50. Does this make sense to everybody? But keep in mind, if you ever push or kick or hurt the police officer while they're doing the pat down, that can lead to a charge for assault and battery on a police officer. So that's a pretty serious charge, and you want to avoid doing that. It's better to ask the officer to give you time to breathe and get your wits about you before fighting them. It's much better to do that. And
how? All right, everyone, excellent. The replacements.
We're gonna do offenses for 300.
Offenses for 300.
Rebecca enters a neighbor's house to find and steal jewelry and cash. Climbing through an open window, she is caught by a police officer. What could Rebecca be charged with? A, breaking and entering, B, burglary, or C, nothing. Rebecca didn't technically break into the house and didn't end up taking anything. Give us 1 second. All right, we're gonna go with A is our final answer.
A, final answer. Okay, that would be incorrect. Team Lucero, do you want a chance?
Yes, we do. Our team says together. B.
Okay, can you share with me why you chose B?
Sure, we got one of our boys coming up.
Sure.
Speak nicely and just tell the difference.
So,
What is breaking and entering?
What I believe is, like, when you cross a barrier, that's breaking and entering because it's not your property to be crossing. And when you steal something, it turns to burglary because now you're stealing something. Like, so that's what I get from out of that.
Okay. Do we have police officers on that would like to speak about the difference between breaking and entering and burglary? Any officer would like to talk about the difference?
Don't be scared. Don't be shy.
Don't be scared. All right, so in the interest of time, let me explain. So breaking and entering and burglary are actually two different charges. In most jurisdictions, breaking and entering is something that happens into a closed business. When you enter into a business that is closed, you will most likely be charged with breaking and entering. Burglary is an offense that happens when you break into a place that can be inhabited, a home, an apartment, those sorts of things. The likelihood that the structure is inhabited. So certainly a neighbor's home can have someone in it. So the charge would be burglary. Breaking
the other
and entering.
reason it's burglary is because Rebecca had the intent to steal jewelry and cash. And so one of the things the prosecutor will do is say, why'd you do that? Why'd you go into your neighbor's house? And Rebecca will say, well, I was hoping to find stuff and take it. And that leads to a key finding by the prosecutor that you had the intent and you had the action. And so together, that shows that you can be charged with burglary. Does that make sense with everyone?
And anytime you hear aggravated burglary, that means that you have assaulted someone, hurt someone, beat someone up, hit someone. So if you hear anything that's aggravated, that means that you have caused bodily injury or bodily harm to someone.
I'm guessing.
I'd like to add, oh, go ahead, Mr.
No, you go first, sir.
Okay, and I'd like to add, what Ms. Thoreau said in terms of intent, a specific intent. Breaking and entering is a specific intent crime, which means it had to be an intent to commit some kind of crime, because we can find a scenario where maybe somebody's in the house and you've been calling them and so forth, and they haven't answered, and you're worried about them. You get there, you can't get in, so you kick the door in, not to commit a crime, but to find out what's wrong, if there's anything happened to the person. So that's why the intent is very important, and that's the difference between the crime and not being a crime.
I'm really glad you raised that point. The other thing is, back to what Robert was saying about aggravated. If you commit a burglary and you encounter someone and you use any kind of violence on them, you should expect the consequences will be a lot harsher. Anything you see in this game, if violence occurs, expect the consequences to be a lot harsher, okay? That's how our system works.
Okay, excellent. Team Xenoff.
We'll take interacting with police for 200.
Interacting with police for 200.
Does a police officer need a warrant to pat you down? A, yes, or B, no. Our team's answer is B, no, because a pat down is for officer safety.
Excellent. And we kind of already talked about that question, so excellent point.
Does anybody want to define what a warrant is? We use that word all over the place. Anyone know how to define a warrant in a good way?
Yes.
What is a warrant? It's
This-
when the judge gives you permission to search.
This is Xenoff here. Our boys say that it's when the, oh, I'm sorry, it's Lucero. When the judge issues an order to be searched.
That's perfect. That's exactly right.
Okay. Excellent. Uncle Gary.
Okay. We do interacting with police for 100.
Interacting with police for 100.
Okay, so if a police officer stops you on the street and asks you for identification, what should you do? A, run. B, sorry about that.
A, final answer.
No, that's not my final answer. No, I said A, run. Oh, that's not the client. Okay. Okay. So A, final answer. Okay, no. B, stay put and be respectful. And C, tell the officer you would not speak to him without a lawyer or parent present. Okay, team about the help desk, unmute your mic. Let's get some input into this.
Okay, so if a police officer stops you on the street and asks you for identification, what should you do? I think B would be the best answer without a shadow of a doubt. It's the most respectful, the most respectful response. Sorry.
Okay, Laura, Stephanie.
I'm torn between B and C.
Same, torn between also could be depending on the reason why the police ask you for identification. But, yeah.
I'm with Miel with B, stay put and be respectful.
Okay, Laura, are you there?
Yes, can you hear me?
Oh, yes. Okay.
Oh, yeah.
Was that you or was that Stephanie? It just said something. Is Stephanie there?
Yes.
Yeah. I was just saying I'm torn between B and C. So.
Okay.
Me
Laura.
too. I'm also torn between B and C. So I'd say B would be the best answer, is to stay put and be respectful. Although, depending on why the police officer asks you for identification, then maybe sometimes it would also be safe that you just you tell the police that you will not speak to him without a parent present, especially if you're a minor, I think. So, but for now, I'll go for B.
Okay, and as far as my input, he's not charging you with a crime. He's not, only thing that he's doing is ask for identification. So he's not asking you to speak to him. So when you say tell the officer you will not speak to him without a lawyer, he's not asking you to speak. He's just asking for identification. So my input on that would be C. So, but the majority wins, which was B. Stay put and be respectful. Final answer, B. Stay put and be respectful.
Final answer B. Final answer B. Stay respectful. Stay put and stay respectful. Here's where I will ask our police officers or a police officer, if you could come in here and explain the process that police officers go through to ask general information, name, address, where you live, where you go to school, where you work, your parents' name. I think that would be really helpful, because this may be a little bit confusing with when you have to read rights and when it's not necessary for you to read rights. So if an officer could come in and explain the process of just asking general information questions, that would be very helpful to us.
Oh.
Just asking general information questions. Identification, address, where you go to school, where you're on your way to.
And Clark, for clarity, this is any officer from any team can answer this question,
Yes,
correct?
yes, any officer from any team.
Okay, just in case they think it's for team NVHD. Okay, so any officer that's on the
Yeah,
line.
because the question's been answered already and it's been answered correctly. I just want to make sure that we're talking through the process that police officers adhere to when asking general questions.
I meant to say expound on it.
Yeah.
Going back to that kind of general officer safety idea, just asking someone to simply identify themselves doesn't necessarily mean that you may be bringing charges against them. You may be asking about another crime that happened in the area and perhaps looking for a witness or something of the sort. This is why identifying questions and those officer safety type questions don't necessarily warrant an attorney or parent being present, because you're not necessarily bringing a crime against a youth.
Officer, isn't it the case that you're entitled to have an attorney to answer questions once you are in custody? But until then, you can answer questions or at least give your name and your address and age. Answer those pieces of information, but you're not entitled to an attorney until you are in custody.
That is correct.
Yeah, I also want to point out that every time a police officer talks to someone, it doesn't have to be a crime involved at all. They don't have to be conducting an investigation at all. I can remember plenty of times just driving down the street as a police officer and just wanting to talk to the kids, just get out and, hey, my name's Officer Clark. What's your name? Who are you? Where are you going? What's up, guys? Girls, just trying to get to know people. That doesn't necessarily have to be an investigative process for any reason, but really just a community policing effort and trying to get to know the people that are in your area of responsibility. So I don't want us to walk away thinking that every time a police officer talks to you, they're investigating something, because that's clearly not the case. I know that's the perception that may be out there in the media or video or things we see on television, But for the most part, that's not the case. Police officers are just trying to get to know people who are in their area of responsibility, or at least they should. I'm sure that that's still a very popular thing for police officers to do, to just talk to people and get to know people who are in their area of responsibility.
I'm also wondering if any officer could comment on why running is not a good idea. What do you think when you see someone run when you approach them?
Guilty.
The general
Guilty.
perception, yeah, that general perception is that you've done something wrong, which is why you're running. So it's never a good idea to run.
Thank you.
Usually not. Excellent,
Okay,
excellent.
Okay, so this is Uncle Gary. Not from Michigan. In Michigan, and it may be the same in Nevada, but in Michigan, the moment you are placed in handcuffs, you're under arrest, and then your Miranda rights come in at that point. Is that the same in Nevada?
Well,
I'll let an officer respond to that.
Being placed in handcuffs has nothing to do with whether or not you need to be read your Miranda rights. You could be placed in handcuffs simply for officer safety.
Right.
So would you be under arrest if you're placed in handcuffs?
no. No. Many states will have you, for instance, you're stopped, pulled out of a car on the side of the road, you will be handcuffed as an officer runs information on you, and that is a detention, not and it's arguable whether or not you're in custody, but you are not automatically Mirandized in many states. This is a highly litigated point, but officers can do that for safety. So young people should know too that just because they're cuffed does not mean they're arrested. It means that is what the officer is doing while they're checking out information about you. And the best thing is to sit there quietly.
So there's been a lot of controversy with this, and I've talked about this over the last couple of weeks. There used to be techniques that were done by various police departments across the United States, most famously the Los Angeles Police Department. They would get everyone on the curb, kneeling, sitting, handcuffed, while they conducted those street stops and street investigations. Those individuals weren't necessarily under arrest. In 2021, we are under a different premise of policing and law enforcement. Some departments have gone away from that technique. Some departments are still doing that. I'm not sure what Las Vegas Metro does in those sort of instances where they may have 6 or 8 gang members together. They're conducting a street stop, a street investigation, checking people for warrants, patting people down for weapons or narcotics or whatever the case may be. So the techniques and the strategies will vary. It's important to understand that when you are handcuffed, that you are being detained. You are not free to leave. No, you cannot walk away with their handcuffs on. So it's important to understand that you are being detained, but you are able to be detained for a reasonable amount of time without being under arrest. It's important to make this distinction. You are, the law provides, the Supreme Court provides that you can be detained for a reasonable amount of time while I check out your ID, make sure you're not wanted for warrants, pat you down for weapons and other contraband, and conduct whatever car stop or street stop that I'm performing at the time. But it's a reasonable amount of time. Now you will ask the question, well, what's reasonable? And it's hard to say what is reasonable because that will vary by circumstances as well. Once you are under arrest, a police officer, as it's already been articulated, will tell you that you are under arrest. They are putting you in the police car and they are taking you to the police station. It is not necessary for them to Mirandize you at that point. You are only entitled to Miranda, which means your right to remain silent, if you are detained and in custody, which means you are not free to leave, and you are being questioned for the crime for which you have been arrested. And it's important to understand that. They may ask you general identifying information, your name, where you live, where you go to school, who's your parents, et cetera, et cetera, et cetera. They can ask you all of that identifying general information without Miranda. If you are in the back of the police car and the police have not Mirandized you yet, and you start just yelling in the back of the police car, Tony gave me the gun and I got the bullets from Robert and Lisa gave me the drugs. Those are called spontaneous utterances, and those are not covered by Miranda. Those will be admissible in court. Those will be put into the report, and they will be admissible in court. They are not covered under Miranda. In other words, you can't say, well, they didn't Mirandize me, so that they can't use that. Yes, they are allowed to use what's called spontaneous utterances. The Supreme Court also allows for this. Is that clear, or did I just make it more confusing for everyone?
For me, it's clear.
Okay. So the techniques will vary from jurisdiction to jurisdiction. So Michigan may do things one way versus Nevada versus California versus Chicago versus DC versus Florida. They may all do various things differently, but it will always still be within the scope of their authority and certainly within the scope of what the Supreme Court allows. All right. Mr. Jones, the Village Foundation.
Okay. We'll take juvenile records for 300.
Juvenile records for 300.
You have been adjudicated delinquent for breaking into a car. How should you answer on a job application? Have you been convicted of a crime? Yes or no? We're going to mute and discuss it. Okay. The answer is no. B, final answer.
Correct. Mr. Jones, would you be able to expound a little bit on why that would be the case?
Now, the job application, if you're talking about a job application, we're not completely sure if that requires that's information that that's protected as far as juvenile rights are concerned, number one, and number two, yeah, we believe that information is protected.
Lisa, would you like to talk a little bit about that?
You're absolutely right. When you go to juvenile court, you're not convicted, you're adjudicated. So anybody listening to this who's going to fill out a job application anytime soon will see that the question says, have you been convicted? But because if you've gone to juvenile court, you can't be convicted, you can only be adjudicated. You can totally honestly say, no, I have not been convicted of a crime. I have been adjudicated delinquent. You don't have to say anything else. Okay, this is really important. We don't want you to miss out on getting jobs because you don't know how to answer this question. So if you've only been in juvenile court and you've only been adjudicated, you can say no to the question, have you been convicted of a crime?
Excellent. Team Cohen.
Team Cohen chooses juvenile justice overview for 300.
Juvenile justice overview for 300.
If you have a juvenile court record, can anyone access your record? A, yes, B, no. Cohen choose B, no.
Good work.
Excellent. Excellent.
That's right. Nevada is one of the best states for protecting juvenile records. You get a lot of protection in Nevada. It strongly believes in second chances for youth. So in addition to saying no to any question about whether or not you've been convicted of a crime, because you've only been adjudicated in juvenile court if you've gone there, you should know that very few folks in Nevada have the right to see your juvenile record.
Excellent.
That should make you feel hopeful and like you should look for every job that interests you.
Yeah, that's exactly right. Team Wilson.
Offenses part 2 for 300.
Offenses part 2 for 300.
You skip 3 appointments with your probation officer and get arrested for violating your conditions of probation. What could happen? A, your probation terms could be extended. B, you could be put in detention. C, if you are over 18, you can be placed in county jail. And D, all of the above. Give us a second, please. Okay, we are ready. Hold, please.
The answer is D, all the above.
Excellent.
And he would also like to explain why.
Yes, absolutely.
The reason is your probation. If you're on probation and you're over 18, you can be placed in county jail because you violated your probation. If you're under the age of 18 and you violate your probation, you can get sent back to detention. Your probation could also be extended because you violated your probation. You didn't commit to the terms of your probation.
Excellent.
I don't know who's speaking, but I think he needs to be a lawyer. If this young man could tell me what's the best strategy to use if you're going to miss an appointment with your probation officer, what would you recommend?
A doctor's appointment.
No. What is it? So, how would you best handle this appointment? So, if you know you're going to miss an appointment, what should you do?
I should contact my probation officer and let her know why and when I'm going to miss the appointment.
Exactly. It's better to call in advance, okay, than to get a violation of your condition of probation. Did you know that in Las Vegas, violating your condition of probation is the third largest reason young people are arrested? Think about it. It's much better to call your probation officer and explain what's going on than to get arrested again for it, okay?
You've done a very good job, young man. I'm very proud of you. Just the way that you articulated yourself
That
was exceptional.
perfection.
Yeah,
good job.
Exceptional. The replacements.
All right, we're gonna take offenses for 200.
Offenses for 200.
Leah's caught shoplifting $500 worth of clothing at a mall near her house. What will happen to her? A, nothing. It's her first offense and the store owner will let her off the hook. B, she may have to make restitution, meaning she will have to compensate the mall for what she stole. C, Leah could be charged with petty larceny. Or D, B, and C. Give us one moment. We go with D, B, and C.
Excellent.
B and C. Excellent. Excellent.
You want to explain, bro?
Yeah, you want to explain? I'd love to hear an explanation.
Yes, I say D, B, and C because she was stealing and petty larceny is under $1,000, I believe. And then 2, just because it was her first time getting caught stealing petty larceny, you could still go to jail.
And tell us why you chose restitution.
Because whatever she stole out of the mall, you're gonna have to pay that back whenever you get released.
That's excellent.
I thought that she was caught shoplifting, so she never really actually got away with it. So the restitution. Restitution. I'm not sure how that applies. Not at least not in that context.
Can you repeat that again?
Oh, okay. Lisa's caught shoplifting, $500 worth of clothes at a mall near her house. So my position is that if she got caught, then they got the clothes back. So restitution would have to be for something else, maybe the trouble they went through in calling the police, but the clothes themselves never left the store, according to the question.
Are you a lawyer? Let me just ask, are you a lawyer? Very good analysis there.
Paralegal.
Well, let's say if they were not able to recover the clothes, that's when she would have to make restitution. And we just want young people to be aware of the fact that increasingly stores are asking for restitution, either in cash or in work. So you really want to understand that not only could you end up facing a criminal charge, but you may have to work off what you owe. So keep that in mind.
Excellent. Okay, Team Lucero.
Lucero, it's juvenile records for 200, please.
Juvenile records for 200.
Who might be able to see your juvenile record? A, mental health and medical services. B, immigration, public housing, and Department of Motor Vehicles. C, your principal and other school administrators. D, a judge sentencing you in adult court. E, all of the above. After much discussion, our boys say E.
Correct. Correct. So it's a little hard to find some of this information in your state laws, but it is definitely the case that a judge sentencing you in adult court is likely to have access to your juvenile records and consider it. So if you keep making the same kind of criminal activity and now you're an adult doing it, they're going to say, come on now, and probably lead to a harsher punishment. Your principal and other school administrators often are going to be able to see your juvenile record, although I can't exactly explain to you how that's going to happen. Definitely the Department of Motor Vehicles can see it, so you may not be able to get your record, your license, I'm sorry, your driver's license or your driver's permit. If you, for instance, are charged with possession of drugs or a minor in possession of alcohol. So for all those reasons, you want to be careful, even though a lot of folks can't see your juvenile record. This is a definite risk for some of these folks.
Excellent. Team Xenoff.
We'd like to take offenses part 2 for 200, please.
Offenses part 2 for 200. Okay.
Your partner's ex hates you and gets in your face saying, one of these days I'm going to mess you up. If you punch them in the face in response, can you claim self-defense? A, yes, or B, no. We have a resounding B over here, no.
Excellent. Why not?
Yeah, exactly. Why not?
Being yelled at alone doesn't necessarily present a threat to your safety.
Excellent. And is this person promising to punch you or mess you up today?
No, they're not. The threat is not imminent.
Okay, so it's got to be right amount of, it's got to happen at the moment, okay? Also, when you respond, your response has to be proportionate to the threat. So if someone punches me, I can't shoot them and feel like that is going to get me a self-defense claim, okay? This is going to be at the moment, and you have to often try to escape, and you have to use the same kind of force as was used on you. So I know in some states, even waiting 20 minutes means it's not self-defense.
But Team Xenoff, what would you be able to do short of punching them in the face? What would you be able to do? We've talked about what you can't do, but what can you do?
Great question, Robert.
What can you do?
A report can be made if you do fear that that threat might be legitimate.
Okay.
If
Great.
threats continue, you can also charges.
Okay.
Excellent.
So this is where I've always tried to tell people that sometimes you may not have the opportunity to file a police report, and it depends on the department that you're dealing with, but it's always critical for you to file what's called an incident report. It's not going to go anywhere, but it documents the incident, because one or two incidents may lead up to an event. It may lead up to a crime. And a lot of times when I've talked to victims, they say, well, this has been happening for a long time. Do you have any documentation of that? Well, no, I don't have any documentation of that. Did you file an incident report? No, I didn't file an incident report. My department doesn't allow for that, or the police department doesn't allow for that, or I didn't take the time to do that. Then it makes it very difficult for the detectives and the prosecutors to really kind of work the investigation, because whatever has happened that has not been documented could potentially be lost in a future prosecution. So yes, you'd have the opportunity to file an incident report if your department provides that, or an incident or an actual police report of an event where that can be evaluated by a detective and a prosecutor somewhere down the line. So it's important to know not only what you cannot do, but what you can do in order to protect yourself. Excellent. Uncle Gary.
Hey. Okay. So juvenile justice overview for $200. What? Dr. Clark, did you hear me?
I'm sorry, I did not hear you.
Okay, I'm sorry.
You broke up. You broke up a little bit. I'm sorry.
Oh, okay, okay. Juvenile justice overview for 200.
Okay, there you go. You're clear now.
Okay, thank you. Okay, so which statement is true about juvenile arrests since 2000? The number of juvenile arrests has gone down a lot since 1996, or B, the number of juvenile arrests has gone up since 1998. Team Nevada Help Desk, your response?
I'm going to go with B, the number of juvenile arrests. Oh, actually, I'll go with A. I don't have too much reasoning for this. I just maybe have a feeling that there's been a change in regulation since then, or there's been a lot of change in regulation since 1996, and that would cause it, or that would cause the number of juvenile arrests to go down.
Okay. Stephanie?
Yeah, same with me. I'm going with the feeling of letter A.
Okay.
I'll also
Laura?
go with A, Uncle Gary.
Okay. Mia? You still there? 3 seconds. 1. Okay. So majority wins. We go with A. Final answer. The number of juvenile arrests has gone down a lot since 1996.
A is correct. Remember, this is when we've been talking about the height of the crack epidemic, the gang epidemic, drive-bys, gang members doing carjackings, and all the things that happened during the 90s. Juvenile crime has gone down since then significantly. I don't know what it was in Las Vegas, but in LA, they had 1,300 murders in the early part of the 90s. Now they're under 300, so certainly it has gone down. Excellent.
But juveniles were never the major source of the murders, even in the early 90s. And you should know that juvenile crime right now, juvenile arrests, are at their lowest since they were first measured in 1974 with the enactment of the Juvenile Justice Delinquency Prevention Act. So the key thing to keep in mind about this is there are a lot of adults out there who think the answer is B, and that juvenile arrests have actually gone up a lot. So keep in mind that a lot of what the media portrays about young people is that they're violent and dangerous. And when you're a young person, you have to kind of manage how adults think about you, or be aware at least that a lot of adults are scared of young people. So keep that in mind, and keep in mind that the fact is juvenile crime and juvenile arrests are way down. So don't let anyone tell you otherwise. And of course, let's hope it stays down.
Yeah, for sure. Mr. Jones.
Okay. Let's go offenses for 100, please.
Offenses for 100.
Yes. While leaving a store, Jake is insulted by a man behind him in line. Jake punches the man and breaks his nose. What could happen to Jake? A, because Jake is a minor, he cannot be charged with battery. B, Jake could be charged with simple battery. C, because Jake caused serious harm, he could be charged with a felony according to Nevada law. D, Jake can be charged as an adult for a felony offensive battery. And E, C, and D. We're going to mute for a discussion. Okay, our answer is E, both C and D.
C and D. Excellent. And the reason for that would be obviously because Jake has assaulted someone, which has caused serious bodily injury. And under Nevada law, that would be covered under the battery statute for the type of injury that Jake caused. And he could be charged as an adult depending on his age. Okay. Team Cohen.
Team Cohan would like juvenile records for 100.
Juvenile records for 100.
If you are found guilty in juvenile court, you have been A, convicted, B, adjudicated delinquent. B, adjudicated delinquent.
B, final answer. Correct.
Yay, you were listening.
Yeah,
Okay.
and we've covered
adjudicated.
that quite a
Thank you.
bit. Yeah, excellent.
Good. Thank you.
Team Wilson, final question.
Offenses part 2 for 100.
We're ready.
Your friend gives you a ride home and the police stops his car. They see a bag under the seat and find pot in it. What could happen? A, nothing. It is not yours. B, nothing. If it is under 1 ounce. C, charged with a misdemeanor possession of and a $600 fine. And D, felony possession, charge, and mandatory jail time. What are you guys thinking?
I'm thinking run.
Still talking about it. Give us a second.
Okay, take your time.
We're under the assumption that you guys are talking about a juvenile, not an adult. Any
That's right.
clarification?
That's correct.
Okay. All right. Thank you. Team Wilson choose C, charged with misdemeanor possession and a $600 fine.
C, correct. So this is where we would talk about quite extensively the significance of riding around in cars with people without knowing what's in the car. It would be the same conversation if there was a gun under the seat where you were sitting, you could be charged with that gun. Now, something may happen different down the road once it gets to court, but for the officer out on the street making that car stop, if they find drugs in close proximity to you, a weapon in close proximity to you, you could be charged with possession of those drugs or of that weapon. And again, something different may happen once it gets to the prosecutor's office or once you get to court personally. So certainly it's important to understand and be aware of when you get into cars with different people.
We really want you to be careful here because your friends can be your destiny. You know, they can put you in situations that can really affect what your options are going forward. And just know that if someone asks you to hold a backpack and you don't know what's in it, you better think twice. If you're in a car and you're within arm's length reach of whatever is seen to be contraband, that, you know, like a gun or like you're saying, pot or some other kind of drugs, they're going to consider that yours. So at the point when the officer is dealing with you, you're likely to be charged as though you were the owner. And as Robert said, maybe down the line, you can make the case it wasn't yours, but until then, it will be assumed to be yours. So please be careful. Think about who you're getting a ride with. All right.
Yeah, as ridiculous as it sounds, in 35 years of law enforcement, I've heard probably a couple hundred times, this is not my car, this is not my backpack, this is not my coat, these are not my pants. I've heard all of that when it comes to finding things on people. So at the time, the officer will make a decision and the court may decide to do something else, but certainly you should be aware of what you're accepting and what you're involved in, particularly if you're taking rides and holding things for people. It could really get you into trouble.
And think about it really carefully. I was in LA once doing a ride along, and I watched a young man and a young woman who were charged with threatening a store owner and stealing from him. And the young man ran and he put the gun he had used in his sister's pocketbook, her purse, and she was charged with possession of a weapon. And so her life got ruined too. So please, please think about these things. Think about who you're hanging out with and what the risks are.
Excellent. Okay, there's a bonus question. Yep, it didn't click, so that doesn't work. So this is the breakdown of the points. As Dr. Malone has said, everyone will have will get gifts for today. Let me see what's next. Oh, I'm sorry, there the bonus question is. It did come up. It was after that. Let me see. So the replacements. This is your question. It's flashing on you, so we'll give it to you.
All right, sorry. When the police approach you to frisk you, what should you do if you have a weapon on you? A, run. B, keep your hands up in the air. C, stand still. D, tell the police where the weapon is. Or E, B, C, and D. 1 second.
All right.
Are we wagering them out?
Yeah, I'm going with run. I don't know what you guys are doing. I'm going with run.
I'm with you, Dr. Clark.
Excuse me, Mr. Clark. Do we need to wager an amount, or
No, you don't. No, you don't.
Okay, we're gonna go with E as our final answer.
E. Oh, I think this was one for everyone. Yeah, so it's E.
All right. Well, this has been super impressive. If we could just stay for one quick second on this last question, is there any officer on the line who wants to talk about the best way to handle a situation? Like if you do have a weapon on you, what to do if an officer comes up to you?
To put it simply, officers don't like surprises. So the best thing that you can do is listen for their instruction, be patient, and follow that instruction.
That is great advice. Great
Couldn't have put it any
advice.
simpler than that. Thank you.
I want to tell you guys one story. I heard it from a judge. He said that a young man had a gun on him and police were coming towards him, and the young man ran for fear that he would get in trouble with having a gun on him. And he ran and shot the gun until it was empty of bullets. And then he stopped and put the gun down on the ground. Meanwhile, police were running after him and shooting at him, and they missed him. And they did not see that. And then they see that he put the gun on the ground and he's standing there with his hands up in the air. And they rushed up there to the young man and said, why did you do that? Why'd you keep shooting the gun? And he said, I thought I would get a harsher charge if they found that the gun was loaded. So I wanted to empty the gun. Okay. So this is not a good idea. Don't do what that young person did. If you have a weapon on you, stop, stand still, do not move, and not try and empty the gun.
Yeah,
Everybody-
don't try to empty the gun.
Yeah.
Are there any last questions from any of the teams or team leaders? Anything that was not clear? Anything that you would like more clarification on? Any examples or stories you would like to share?
Now, the Village Foundation is good. We thoroughly enjoyed the process and the game.
Thank you,
Great.
Mr. Jones. I appreciate
We're
you.
wondering, before anybody hangs up, we're wondering, could each team tell us one thing they learned that surprised them or they didn't know before?
I would say one thing that stuck out to me was that conversation we just had about letting the officer know, like, if you have a weapon on you. That would be very, very smart if you were in an altercation with
Yeah.
How about another team?
Well, for me, this is Uncle Gary. Obviously, for me, it was the handcuff thing. I would do a little bit more research on that one because see,
Okay.
once my movements are restricted, then I technically, personally, I consider myself under arrest, not under detention, but under arrest. So I'm gonna do a little bit more research on that one.
You're in custody, but not necessarily arrest. It's arrest, custody, detained.
Oh, okay.
How about Team Combe?
One of the youth stated that, you know, the pat down of females was very informative for him.
Thank you. Team Lucero?
We're having one of our boys come up.
Great.
So, you know, what was very important to me is that at the age of 10, you can be convicted for a crime. I mean, adjudicated, my bad. That's the wrong word.
Oh, very good. Yeah, it's shocking, isn't it? Well, maybe you can be one of the youth advocates and community organizers who are trying to raise the age. That's a big movement, both to raise the lowest age at which you could be arrested and the age at which you can stay in the juvenile court till 21. So thank you for sharing that. How about the replacements?
I'm sorry, we were holding a group discussion. What was the question again?
Could you tell us something new you learned or something that surprised you?
Yes. Yes, I would say the question we got wrong. I believe it was offenses because we went with breaking and entering, and then the right question was burglary. But shouldn't it be attempt burglary because she got caught trying to go through the window by a police officer? She wasn't she wasn't all the way in the house, and they didn't say the question like. In the question, they didn't say if anyone was in the house or actually stole something.
Well, I think we have a defense attorney here who's a natural lawyer here trying to challenge the charge and make it seem less bad. But you absolutely could argue that. And I say hats off to you to think a bit. I think what we had in mind was someone who was partially in and caught in the act. And so that's why it still would be burglary because you still entered without permission. But very good thinking there. And I bet you could persuade a jury because you're a persuasive speaker.
Thank you so much. We appreciate it.
No, we appreciate you.
How about Team Xenoff?
Hello, we have two youth here.
Oh, good.
Go ahead.
I said I learned that youth don't get convicted, they get adjudicated.
Great.
And number
So
two?
you learned that.
I learned that when you get pulled over by a police officer, you should follow all their instructions because there could be repercussions and consequences to that.
Wonderful. Wonderful. Okay, and remember, sometimes they may cuff you while they're running your information, but it doesn't mean that you've been arrested. It means they're detaining you while they're investigating the information about you, okay? So it's best to stay calm and quiet.
Yes, ma'am. Thank you.
Have I got all teams or did I forget any team?
Team Wilson.
Somebody on my team.
Good, thank you.
I had learned that when being detained and arrested are two different things, because detained can just be like they're running your information, waiting to see if you got a warrant or something for your arrest, and arrested is being like you coming down and be booked in a detention facility.
Right.
Wonderful, wonderful. Well,
Uncle Gary, I'm sorry, Lisa. Uncle Gary, your team have something?
Yeah, maybe my team. I already spoke my piece, but Laura, Stephanie, Amani, and Miel.
I would say one thing that I have learned was it was one of the last ones where if you have anything to tell the officer while they're searching you, that you should speak up before they find it, and that it is a much better idea. Just in this is kind of just something I learned through seeing the response to all the questions, which is it's just a much better idea to just stay calm and stand still. Just so that nothing happens or nothing bad happens.
outstanding. Great words to end on. And I think Dr. Malone has given me permission to say that if you like this game, if you have ideas for other topics and other questions that this game could focus on, you can send her an email or let or your game leaders know in your different sites. And we're hoping to come back and make more games like this and do it with your input in the future. I think you can email through Jody. Is that right, Dr. Malone?
And yes, those that are at Juvenile Justice Services, all the 5 teams that represent JJS would go through Jody. And Jody, if you will email me, and then for Village Foundation, of course, Dr. Young and Uncle Gary, you have my email. And to that point, Lisa has given you all, I got a big box here of all these pamphlets that everyone will get a copy. I have an appointment with Jody next Tuesday. I'm gonna be delivering all these Be Smart with Police by Strategies for Youth, connecting cops with kids. It's like a little handout pocket. You can carry it in your pocket, kind of the do's and don'ts. Really neat. You all also, every single participant today will get a certificate of participation, and every single person and their leaders, understanding there's 2 leaders per team and 7 teams that participate today, every single student and leader will get a $25 Grubhub gift card for any restaurant that is basically anywhere. Everybody accepts Grubhub, and that's $25 for every single participant today as a thank you. Woo, courtesy of our sponsors. Got to say their names.
Oh, wow.
Streaming. And our sponsors are, of course, Nevada Help Desk, Tech Queen Elite Training Institute, Anthem Medicaid, Las Vegas Metropolitan Police Department, Bolden Area Command. All of those are our sponsors for today. And thank you. Shout out to Livia. Woo!
Thank you, Robert Clark. Thank you, Dr. Malone. Thank
And
you all.
Robert Clark, our facilitator today, and thank you for a facilitator, and we'll have a special thank you for you as well, and of course Lisa for all your hard work. I got your address on the return address box here, so we're going to be sending you a nice little thank you also.
Thank you all so much. I hope to see you in Las Vegas.
Absolutely, absolutely.
And the last thing that I'm sorry, Uncle Gary, go ahead.
Okay, I just want to personally thank Mr. Rowe and you, Dr. Clark. Wonderful job. You know, I told you I was a paralegal, so this took me back to my paralegal days. So I really enjoyed this. So thank you so much. You were wonderful.
Thank you, officers.
So the last thing I wanted to share with everyone is this information is important, but it's only important if you share it with other people. You continue to have conversations about the information that you learned. It's important for all of our youth, especially, to really understand the do's and don'ts that police officers can do and cannot do, and what you should do and should not do. We are in a very critical time in law enforcement where there's a lot of mistrust, there's a lot of lack of communication, but we have to remember the women and men who are out there working every single day to do the right things, to make friends, to service their community. It's important that you and we reach out to them, support them, pray for them, encourage them, continue to protect them, because again, a society without law and order is no society at all. So I encourage all of you to share the information that you've received today and befriend a police officer. When you see a police officer, thank them for their service. Ask them their name. Ask them how to become a police officer. I remember when I was young, that's how I got started, is that I asked the police officer, how do I become a police officer? It's not a job for everyone, but for those who are encouraged, just ask. Take an interest in what law enforcement does, because law enforcement is really about servicing your community, serving where you live, wanting to see things be different in the community that you live. And that's all our police officers are trying to do, is just to make a difference. So thank you all for participating. Thank you all for your enthusiasm today. I thank all of the law enforcement officers who were present today. Continue to be safe out there. We'll be praying for you and supporting you. And just thank you all for participating today.
Oh, one thing, Dr. Clark, I forgot to thank my niece too. I don't want to forget her, the tech queen.
Thank you. And thank you to all the young people. We wish you all the best.
And can the Village Foundation say how much we appreciate the opportunity to be involved? We want to thank Anthony Jones. He's a former school police, a very capable one, and did so much work for many students by just taking time to listen to them, to encourage them, and to counsel them individually and say, hey, here's a better way to do this. You don't want to go that direction. And so thank you so much, Anthony, and for all your hard work. You did 30 years in the Clark County School District.
Wow.
Isn't that something?
Wow.
30 years. So
Thank you,
all.
Dr. Young. I appreciate it.
Wow.
God bless.
Thanks.
Wow. Woo.
Bye.
We got 8 minutes left in our day.
Thank you, guys.
Thank you.
Bye-bye.
Bye-bye.
8 minutes.
Congratulations on a successful event. Congratulations.
Thank you. Thank you.
We had fun.
Thank you, Dr. Malone. You're the
We
best.
had fun. Thank you,
are.
Dr. Clark and Lisa. And
The tech queen. Okay.
yes, ma'am. Yes, that's another gift. 8 minutes. All right.
Happy Easter, everybody.
Bye, Lisa. I'll talk to you soon.
Bye-bye. Bye, everybody.
Bye.
Bye-bye.